Can a limited liability company qualify for 501c3 nonprofit status? This question arises frequently for those looking to establish charitable organizations while maintaining the flexibility of an LLC structure. While LLCs are traditionally for-profit entities, they can function as nonprofits under specific conditions. The protection a limited liability company offers its members is one of its most attractive advantages, as members are generally not responsible for the debts and obligations of the LLC. Technically, there is no such thing as a non-profit LLC in the traditional sense. However, in most states, LLCs can be tax-exempt under certain circumstances. These are sometimes referred to as non-profit limited liability companies, tax-exempt LLCs, or non-profit LLCs. Non-profits are usually formed as corporations, but they can also be structured as limited liability companies in some jurisdictions. An LLC can operate as a nonprofit if it is solely owned by a single nonprofit organization and meets all requirements set forth in the Internal Revenue Service's Limited Liability Companies as Exempt Organizations Update. The IRS has specific requirements for an LLC to qualify for 501c3 status. First, the LLC must be wholly owned by a single 501c3 organization or multiple tax-exempt organizations. Second, its purpose must be exclusively charitable, educational, or religious in nature. Third, the LLC must include a dissolution clause, stating that upon dissolution, all assets will be transferred to another tax-exempt organization. Additionally, the LLC must not engage in substantial lobbying or any political campaign activities, and its operating agreement must align with state nonprofit laws. Failure to meet these guidelines could result in the IRS denying tax-exempt status. State laws significantly impact the formation of nonprofit LLCs. Some states explicitly allow nonprofit LLCs, while others require nonprofits to register as corporations instead. Certain states impose restrictions on tax exemptions, limiting the ability of nonprofit LLCs to access the same benefits as nonprofit corporations. Before proceeding with formation, it's essential to check with your Secretary of State's office or consult a nonprofit attorney to ensure compliance with state-specific laws. Most nonprofit organizations choose not to file as LLCs because the process can be lengthy and difficult. All owners of a nonprofit LLC must have 501c3 status, meaning all members would have to incorporate as nonprofits first, then form the nonprofit LLC. This arrangement might make sense for a group of existing nonprofit organizations coming together for a joint venture, but it's rarely the simplest approach. A corporation is typically the most appropriate way to form a nonprofit. Corporations are governed by a board of directors, which is why some states require nonprofits to be corporations. The internal rules for the nonprofit are drafted by this board, providing clear governance structure. Organizations with 501c3 status enjoy several tax benefits. The Internal Revenue Code allows these nonprofits tax-exempt status, meaning donations to them are tax-deductible. They avoid federal corporate income tax and, in most states, state tax, sales tax, and property taxes as well. Nonprofit LLCs with 501c3 status can enjoy these same tax exemptions, but financial management differs from for-profit LLCs. These organizations must maintain strict financial transparency and file annual reports to retain their tax-exempt status. Many grantors and donors prefer to fund nonprofit corporations over LLCs due to uncertainties in compliance and the more established nature of nonprofit corporations. To address some common questions, an LLC cannot apply for 501c3 status directly. It must be wholly owned by a 501c3 nonprofit or another qualifying entity. Forming a nonprofit corporation is generally easier and more widely accepted for tax-exempt purposes than an LLC. If a nonprofit LLC violates IRS rules, the IRS may revoke its tax-exempt status, subjecting it to corporate income tax and potential penalties. A nonprofit LLC can have multiple owners, but all owners must be 501c3 organizations or other tax-exempt entities. And yes, nonprofit LLCs provide the same liability protection as for-profit LLCs, with members generally not personally liable for the debts of the organization. In summary, while it is possible for an LLC to function as a 501c3 nonprofit under specific conditions, most organizations find it simpler and more advantageous to form as nonprofit corporations. The requirements for nonprofit LLCs are stringent, and compliance with both IRS regulations and state laws is essential. Before establishing any nonprofit entity, consulting with a qualified attorney who specializes in nonprofit law is highly recommended.